today's session is Leaving Your Job, Your Legal Rights in BC. We are thrilled to have you here with us today. My name is Paula Price. I'm with the People's Law School. I'll be your host today. We have two incredible guests, Richard Johnson and Aaliyah Varani, who I will be introducing in just a few minutes. Now, as I mentioned, today's webinar is all about quitting your job in British Columbia. You will learn your rights and responsibilities when you quit your job, whether it's because you want to or because you feel like it's the only option. You'll also learn about action steps that you can take and where you can find help. What you can expect today, we have about 60 minutes together. We will provide answers to your questions. What you will receive is legal information, not legal advice, and it's current as of today. Now, if what you're looking for is the law as it applies to your unique set of circumstances, that would fall under legal advice. If that's what you are looking for, then we would invite you to reach out to a lawyer. You're more than welcome to reach out to our guests from today's session, Richard Johnson and Aaliyah Varani. Their contact information is on the screen. We acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everyone who has joined us to reflect on where it is that you're joining us from today. We would also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose funding makes production of today's webinar possible. And finally, we would love to welcome and thank and introduce our speakers, Aaliyah Varani and Richard Johnson. I will start with Aaliyah. Aaliyah is a workplace lawyer with Ascent Employment Law. She advises her clients, who are employees and employers, on their legal rights in relation to the workplace. And so those are contractual rights, common law rights, rights in relation to employment standards, human rights. And we are thrilled to have her here with us today. The approach that she takes in her practice is one that is tactful and sensitive to the matters that are brought to her. And she believes in tailoring the advice, of course, to each specific situation. And I think we will see that will be reflected as we go through today's session. A big thank you to Aaliyah. She has been instrumental in putting together the questions for today's session. She sent me the most common questions that she receives in her practice. So a big thank you. She also has previous experience on global radio where she has been interviewed in relation to workplace questions. Welcome, Aaliyah. We are so happy to have you here with us today.
Thank you.
Now, we also have Richard Johnson. Richard is the co-founder and principal of Ascent Law. He's also, in addition to being a lawyer, he's also a chartered professional in human resources. Like Aaliyah, he advises his clients in relation to rights in the workplace. Richard is also a legal reviewer, so he has volunteered to help the People's Law School and the Dial a Law website in reviewing some of the pages that you'll find on the website that relate to employment matters. And in particular, there's a page, it's called If You Quit Your Job. It's on the Dial a Law website. And I mention this because that page alone in the last 12 months received over 52,000 visits, making it the most commonly trafficked site on the combination of the Dial a Law and People's Law School web pages. So this is a topic that is near and dear to a number of individuals. And so we're so happy to have Richard here, to have Aaliyah here to help with those questions. So welcome, Richard. We are so glad to have you here.
Many thanks for having me. It is an absolute honor.
Wonderful. And with that, we are going to dive into the substance of today's discussion, starting with our first question. And this question is for you, Richard. Do I need to give notice to my employer if I quit my job? And if so, how much notice do I need to give? And what if it's unbearable and you just want to leave?
All right, so this is a great set of questions, and we face this very typically in our practice. It's really important to mention at the outset that when you're in an employment situation, there's always a contract of employment. Sometimes it will be in writing, sometimes it won't. Sometimes if it is in writing, it may say we need you to provide a certain amount of notice if you're going to quit. That becomes a term that's binding. So if your contract in writing says you need to give 2 weeks, then really you should be abiding by that. Otherwise, there's a risk of a breach of contract, that you, by not providing whatever's written in that contract, are breaching the contract if you walk out the door, except in rare circumstances. So bear that in mind. Take a look at the paperwork you signed when you started, and let's know what that says if it does exist. If not, you've got what's called an oral contract or a verbal contract. And so in that scenario, you don't necessarily know what kind of notice you need to give your employer if you're going to quit. It will be dictated by what kind of a role are you carrying out? Are the duties that you're performing day in and day out something that the employer can relatively easily jump in and fill? So if you were to leave tomorrow, can somebody step in and fill those duties at the front desk or on the factory line? Or are you doing surgery? It really depends on the level of specificity and the technical know-how that's required for your job. In a lot of cases, 2 weeks will be the norm. And so for most positions, people have an expectation that 2 weeks, unless there's something in writing, 2 weeks is generally an acceptable period of time. But the more specialized a position, the more you might be doing something that's unique, it can increase. So if in doubt, 4 weeks is going to be kind of a nice touchstone. But provide enough time that your employer can fill the gap that will obviously be left by your departure. Now, in terms of the unbearability of the situation, if you're finding that you get the butterflies in your stomach on a Sunday night, and you can't bear to go in there one more day, and you just want to leave, you can do two things. You can really relay what it is. Well, think about what it is that's causing that. Is it just that you kind of hate the job? Frankly, you can't stand it? Or is there a hostile work environment? Is there something that's causing an unsafe situation for you when you go in Monday morning and when you're working in your job? If so, then it may, in rare circumstances, be okay for you to assert constructive dismissal and no longer attend. But we do recommend you get advice before you do that, because you don't want to give up a severance right. I don't want to jump the queue, because I know we're going to be talking about that a little bit later. So if there's not a situation that's a constructive dismissal and you just kind of want to start a new job sooner, or you just don't like it and it's become really, really unsavory to go in every day, have a talk with your employer. You could sit down and you could say, I really just don't think my heart's in it anymore, and I know I need to give 2 weeks notice or whatever. Is there a way we can work together to maybe minimize that amount of notice? And so it's really important as you consider leaving a job, that you don't forget that there's somebody else on the other side of that conversation, and they're a human being too. And so you could have a conversation and come to terms that might give you a shorter exit, and also allow them to be able to have some role in what that looks like, so they're not left in the lurch. I don't want to drone on too long, but that's a little bit of my consideration when I'm advising people about what will govern the notice, how much should they give, and then really practically have the conversation, and let's see if we can shorten that if we really want to.
Beautiful. Thank you so much, Richard. Love the foreshadowing of what's to come, the constructive dismissal, and also how you set out the legal rights, but then also this final point about the conversation, right? So much of this boils down to speaking with the human on the other side of the equation and coming up with something that works for everybody, if you can. This next question is for you, Aaliyah. Will I get paid severance if I quit my job? If not, does my employer need to pay me anything?
That's a great question. So, well, if it's truly voluntary, then, and you quit your job and it's completely your decision, you're not forced into it, because as Richard mentioned, we are going to get into some specific circumstances where maybe it's not fully your decision to leave your job. And that's a different thing that we're going to be talking about. But if it's truly your decision, you're voluntarily leaving, then you wouldn't get severance. And you wouldn't be entitled to both statutory severance or common law severance or any amount. The one exception, and it's not very common, is if you've got an employment contract and there's a termination provision that's written in the contract, and maybe you've negotiated a resignation severance amount. It's very rare circumstances. Generally, you see this with an executive level employee. But if you've negotiated that, you'll be aware of it. And so generally speaking, check your contract to see if it says anything about that, if you've forgotten or need to refresh yourself, but it's not something that employees who voluntarily leave their position are entitled to. What your employer does need to pay you, however, is your final wages up to your last date of employment, and any accrued and unused vacation amounts. So Richard mentioned, he touched on this point, that you may have a resignation notice period that you have to provide. So for that period of time, you still need to be paid your wages. And if you haven't taken all of your vacation time and you receive paid vacation as part of your employment agreement, and it can be verbal or written, then you have to be paid out those unused amounts. One thing that a lot of people are not aware of, and that a lot of employers forget, is that vacation pay also applies to any bonus payments you are receiving. So if you were to get, say, like a periodic bonus as part of your wages, and it's based on your length of employment, and it's not something that your employer can decide whether to provide or not provide. And what I mean by that is it's not truly a discretionary bonus, then it's part of your wages. And so what I always recommend people when they quit is to check that they've received all of their accrued and unused vacation payment amounts, and to make sure that's been calculated correctly, because your vacation pay is supposed to be a percentage of your total wages, and your total wages will include any of those bonuses that you received during the year. So that's an important thing that you can make sure that you've received when you're leaving, because you are, like I said, entitled to your final wages and your vacation pay. But other than that, if it's truly a voluntary resignation, then you're not going to be entitled to severance, unfortunately. We will go into a couple of other circumstances when you're quitting or you're resigning, but it's not a true resignation. And in those circumstances, then you can be entitled to statutory severance and reasonable severance. But I'll leave that to the other questions, because it's a bit more specific to describe when that occurs and how you should manage those situations.
Super. Thank you so much, Aaliyah. Richard, this next question is for you. I want to quit my job and give my employer 2 weeks notice. Can my employer tell me to leave right away instead? And would they still owe me 2 weeks worth of pay?
Oh, Paula, this one has two answers, and they're both accurate. Okay. So there will be the practical and there will be the technical legal answer. The answer is, you give your notice and your employer says, we don't want you sticking around. And I don't mean to be trite or flip about this. That can be really shattering. That can be a real sudden, like, right? So I don't want to minimize that. Can the employer do that? Not technically, unless it's in your employment agreement. What they're doing is they're effectively saying, thanks for the terms of your resignation that you gave us. You'll work for 2 weeks. You're proposing that, and they say, no, thank you. Instead, they're terminating your employment when they send you back home immediately and say, don't stick around. So there are two answers. The practical answer is, yes, they owe you the 2 weeks. They owe you whatever the remaining wages you would have earned, and vacation pay, as Aaliyah mentioned. They owe you your compensation for the remainder of the time you would have worked under your resignation. However, they may owe you more. And this is where some advice can sometimes be useful. And I don't want everybody feeling they have to march off to a lawyer or to speak to, some sort of a representative. But it's important to consider that if you've been at a job for, let's say, 10 years and you're terminated, under the Employment Standards Act, you get 8 weeks notice or pay in lieu if you're terminated. So when an employer turns around and says, thanks for your resignation notice, no, we don't want it, we don't accept it, we'd like you to go home right away, that's actually a termination. So you may technically be entitled to 8 weeks pay. So they should give you at least 2 weeks, but you might be entitled to more. So you might want to consider your entitlements before you agree to any settlements, etc. At a minimum, though, you do get the remainder of whatever's entitled over the notice period. And a lot of employers are putting in agreements these days, the written contract. We have the right, if you give resignation notice, to waive the ability for you to work out that resignation period. You don't need to come to work anymore if we say don't worry about it, and we'll pay you the remainder of whatever notice you've given us. But it's to get around this issue of turning it into a dismissal. But you might be entitled to more, but you certainly, want to be thinking about how much time you need to bridge you to the next job, and you should be made whole for that period of time if the employer sends you home.
Super. Thank you so
And
much, Richard. Oh,
my pleasure. And I was just going to say as well, you are entitled to get your personal items too. This is something we commonly face. It's such a human issue. People also, if they have to go home immediately, are surprised because they don't necessarily have their pictures and their little trinkets that they've got at their desk or what have you. And so you have the right to those things back, even if it's at a prearranged time with the employer to go back in or have them send them to you. So just because you have to leave immediately, it can be shocking, but you don't just give up all your rights.
thank you so much, Richard. And just on that last point, emails, like if you've got personal email accounts, you mentioned the trinkets and the photos, would you be able to then recover your personal emails as well? Or is that another topic for another webinar?
It is, let's do it. But really quickly, I think that that's a great consideration in our blended world where everybody's so virtual. We got to be really careful that we're watching what we're putting over our employers' servers and what we're using email for. But a lot of people will send and receive photos of their kids, et cetera, and their partners. And we've got to be very careful once we leave employment to recognize that's the employer's property, essentially, because it's going over their systems. Most employers will send you those things after you leave as a goodwill gesture. But technically, they're not going to allow you to go into their email system again and once you've been terminated or once you've resigned, for fear that you're going to be taking their proprietary information. So that becomes a bit of a sticky issue. But most times the employer will say, we'll send it to you, or we'll download your photos and send you a USB.
Thank you so much, Richard. That's really helpful. This next question is for you, Aaliyah. If I quit my job, will I be eligible for employment insurance?
Okay, so you're going to notice that there's a theme that we touch upon today, and it's kind of like a distinction between voluntarily quitting and then being forced out of your employment. So if you voluntarily quit, then you're generally not eligible to receive employment insurance. You can still get your maternity, parental, sickness benefits as long as you still meet the conditions in order to qualify. But the way that Service Canada defines voluntarily leaving is that the employee took the initiative and it wasn't the employer to end the employment. So as long as you are the one that's truly making the decision to leave, then you're not going to be eligible for EI. But you'll see that there's some, or you may have noticed, or maybe some of the reasons that you guys are attending the conference today or the presentation today is because you want to leave your job, but it's not truly your decision. So in those cases, you may still be able to receive regular benefits through employment insurance. You just need to be able to show that quitting your job was the only reasonable alternative in your case, considering all of the circumstances. And I think one of the participants actually mentioned in the chat to keep a diary. That's a fantastic thing to do. I strongly recommend that you take notes about the things that are going on during your employment in order to really protect your position and protect your ability to receive EI if you feel like you're being forced out. Some of the things that you may have to provide to Service Canada in order to receive EI if you're leaving and it's not your decision. You may need to discuss, show that you first discussed the situation with your employer, your union, or that you requested certain adjustments to be made. You may need to show that you've used some sort of opportunity or alternatives available to you under your collective agreement or your employment contract to resolve things first, and that you really were forced out, and that you anticipated the possibility of transferring to another division in your employment group, or however your workplace is organized, or that you may have worked under somebody else's supervision if it's an issue with, say, your immediate supervisor that's forcing you out. So in those circumstances, if it's not the result of a deliberate personal choice or events that, but instead it's events that occur to you, you want to take good notes about what's happening, see if you can resolve it, like Richard mentioned earlier, with your employer first, or see what other reasonable alternatives there are. And again, take notes of that so that if you do have to leave, then you can at least still get EI, which will give you a good financial buffer in the period of time that it may take to figure the rest of, the next steps out. You can always seek legal advice to help you manage through that process as well. Oftentimes, if you're being forced out of your job, that is the best time to get somebody involved, because it can affect your ability to do certain things, like receive EI, depending on how you set things up, or receive severance, depending on how you manage those issues. But generally speaking, a good thing to remember is, if it's truly your decision, you're not going to be entitled to EI. But if you can show that you've been forced out and it's not your choice, but the choice of your employer, really, that is causing you to feel like you need to leave, then you can justify that and then receive EI.
Super. Thank you so much, Aaliyah. And this next question really does follow up on that. Richard, the question is this: I think I'm going to get fired. Is it better to resign and beat my employer to the punch?
I'm going to give you the lawyerly answer. It depends. And so this again is going to be one where it's technical and practical, depending on which side of the coin you're on. Sometimes. So sometimes, yeah, if you think that you're going to be fired, it can be beneficial sometimes to be able to leave under your own steam. And the reason I say that is because it's easier to go out and say to an employer that you're interviewing with, potential employer, I left because I wanted more of a challenge in my career. I wanted different things. When you message that it was your decision, people can reconcile that and say, well, you're a go-getter. I guess there are reasons you left and you're looking for a better future. And that can resonate a lot better than, yeah, I was fired because I was on my phone at my desk all the time, or because I did something even more serious. So depending on what you think might be coming down the pipe from your current employer, and whether or not it's a just cause dismissal or a without cause dismissal, which I'll unpack in a second, you may want to beat the employer to the punch and say, I'm out, here's my resignation, because I want a message to the outside world I left under my own steam. What you do when you resign, though, as Aaliyah just went into, is you give up the right to EI if you're truly resigning because it's a voluntary choice. You're foregoing your right to claim employment insurance, and you're instead then going to be having to rely on savings or get a new job quicker, etc. So I always discuss with clients this set of considerations. Do you want to quit to be able to message that well, or do you think you're going to need EI as a safety net? Because you can't always have both. The other thing that's important to mention is, if you've done something that is serious and will require a report to the police, or there's some sort of criminal allegation otherwise, or a regulatory issue. So some industries, teachers, et cetera, are regulated. Lawyers are regulated. Doctors are regulated. If there's some sort of a professional misconduct issue, you're likely not going to just escape that by resigning. That may still follow you and be an issue you have to deal with, even if you resign to try to, we call it create the narrative or control the narrative, right? Control the story you're telling. So depending on the seriousness, yeah, it's a consideration, but you may not escape it if it's a very serious issue. It may follow you and you have to deal with it at some point to be able to stay in your career. I won't drone on too much longer unless there's a follow-up question, but that's kind of where my mind goes in terms of the considerations.
No, that's really helpful, Richard. Thank you. Aaliyah, this next question is for you. My job has completely changed. It's no longer what I signed up for. A friend told me it sounded like constructive dismissal. What does that mean, and what happens if I quit?
Okay, it's a big question. It's a very complicated type of claim. So I think the first thing that I should do is describe for everybody what exactly is a constructive dismissal. I think the words get thrown around a lot, but it's important to remember when it is occurring. So if an employer makes a substantial change to the terms of your employment agreement, and this can be verbal or it can just be what you've what you've experienced in practice. It doesn't always have to be a written term of your employment agreement, but if you have, you've been showing up every day, Monday through Friday, and you receive a certain amount of money, and then all of a sudden it changes completely, it's not written down, still a significant change. Or if they demonstrate an intent to not be bound by the agreement, like maybe they stop you normally get your instructions from a dispatcher, and then you're not getting the instructions from that person anymore, and nobody's calling you into work, or you're not being scheduled for work at all, and you're supposed to be scheduled a certain number of hours, a certain days per week, and it's always been like this. Or perhaps you're being bullied or harassed at work, and it's just becoming completely intolerable. Then that would kind of be demonstrating an intention not to be bound by the terms of your employment contract. Then you have the option to treat that as if that's a constructive dismissal situation, you can treat yourself as being terminated. So it's not a situation where the employer says you're fired or I'm letting you go with cause or without cause. Those words are never said. It's constructively, the terms are being changed to the extent that you've been terminated from your position. So you can kind of remember it like that. But it's also really look back to anything that's been significantly changed as part of your agreement. You might see the words fundamentally changed or fundamentally breached in your employment contract. So what happens if you quit in that situation depends on how you frame the situation. And so Richard touched upon this just now, but you can leave in those circumstances if you've been forced out because your duties have significantly changed. I think one note I would mention about that is courts have also determined that small changes over time can add up to a big change. So if you're noticing, say, a pattern, it's very important to keep notes on what's going on. If it's a change in pay, anything from like a 10 to 12% difference in your annual pay per year, anyway. So keep notes and keep track on what's going on. Things like bullying and harassment are going to be more obvious because that's going to be pretty unbearable, but take notes on what's going on. And if it starts to add up to look to what you would consider as a significant change in your normal terms, then speak to your employer about it, raise those issues to them, preferably in writing. I would almost always say in writing is best, and let them know that you're aware of these changes and that there's no reason for them. It's not permitted as part of your contract. You may see a term in your contract, and so it's a good thing also to have that if you do have a written contract in place, to see if they write something like, well, the employer can make certain changes to your duties or your position and it won't be considered a constructive dismissal. Just keep in mind that even though they have those provisions, if they're making small changes over time that add up to really big changes or really big changes, then that's not going to protect them from you saying that it's still a constructive dismissal. So don't be put off by that, and don't think that you have no options just because there is that provision, but really take the time to determine if these are just small changes, like instead of reporting to, John, you're reporting to Jane, or if it's something more significant where you're not getting scheduled 3 days a week, you're getting scheduled 1 day a week or something like this. And if that's the case, then raise it to them in writing and let them know that you're happy to continue on the terms that you were originally hired under. Give them an opportunity to remedy the situation. It's only going to make you look more reasonable and put you in a better position for making any future claim if you decide to do that. It's all about protecting your position and putting you in the best position possible, and also just resolving things if they can be resolved at a very early stage, because sometimes it can be a miscommunication. Sometimes the employer is just not aware of what they are doing because they're managing other things. People make mistakes. But if you think it's more serious and you know that you've raised these issues to your employer before and they're not making those changes back to what you used to have and what you usually expect, and it's going on for some period of time, and you've raised that, again, it's very important to raise it in writing, then you have the option to quit. And then your position's very well protected because you can show that raised the concerns to the employer, gave them an opportunity to fix it. They didn't. And you really quit as a last resort. Also very important for when you want to make sure that you can apply for EI and receive EI in those circumstances. And if you'd like, then you can proceed with making a claim for severance because you've effectively been dismissed. It's not your decision to resign in that situation. You wanted to continue on the terms you had before. Your employer is making these one-sided changes without your permission and without your consent. The fact that your job no longer looks like what it did before means that you've effectively been dismissed and are entitled to the severance under your contract or reasonable severance. And at that point, I would generally recommend that you may want to get some legal advice or, check in with somebody about your entitlements because your employer may, it's generally speaking something that doesn't resolve through negotiation because the employer will take the position that you've resigned and you're going to be taking the position that you've been constructively dismissed. And so generally speaking, most people need a little bit of assistance in getting a resolution that provides them severance. And a lot of these things can be negotiated. We negotiate them all the time. You can get your ROE renegotiated where that term says instead of resignation, it can be, other, code K other, or you can get a severance package and your statutory severance provided to you. But generally speaking, right away, when you quit, your employer is going to take the position that you've resigned. You just have to maintain that you've been constructively dismissed. And hopefully if you've taken the steps before that I've recommended, where you've mentioned it to them in writing and you've kept a written record of the changes that have been made without your consent and shown that you are quitting as a last resort, then you'll be well set up and well prepared to claim severance and receive severance through a negotiation. It happens all the time, but it's just one of those cases where it usually involves getting some sort of outside help in order to reach a resolution.
Super. Thank you so much, Aaliyah. And I'm just looking at the time and our number of questions. So we have a few more questions to go through, and then we're going to move into the live questions that are coming in through the Q&A. Richard, this next question is for you. My workplace has become toxic. My mental health is suffering. What happens if I quit?
We get this all the time. And one of the biggest, or I guess most common impediments in people's consideration about this is, I don't want to be the employee who's on medical leave or stress leave. It's usually and I don't mean to say that this is a wrong consideration or tell people how to feel, but I think there's a real hesitance to be seen as somehow suffering from a medical issue. But we consistently will say to people, if your health is suffering for whatever reason, if you were to slip and fall at work and break your leg, medical treatment can be the way to go in 99% of cases. That's not a bona fide statistic. I made that up on the spot, but you get my point. An overwhelming number of cases where there's a medical issue requires a medical solution. So go to your doctor. It's really important to at least explore your solutions. And your doctor may very well say, we need to take you out of the workplace for a week, a month, 6 months. And what you do by going to see your physician or your therapists is you get chart notes created. So you're creating a record of the issues that have come up. And you're also exploring opportunities where maybe you create some distance between you and work that will give you time to recover, address the issues, get some perspective, perhaps build in some time to negotiate an exit, consider resignation, look for other work. You build in opportunities by doing that. So I would really urge people, and I know Ali and I are both strong proponents of looking at options, right, for our clients. So consider going to your doctor or your treatment practitioner and exploring opportunities. What you also are doing, if you're going to take a medical leave because your health is suffering, is you're continuing to be an employee on the roster with your employer. And so you're allowing yourself access, if you have benefits, to continued benefits while you're off on leave. And that might be short-term disability, where up to, let's say, 90 days or 120 days, you can access wage replacement and you can access prescription coverage and all of the stuff that comes along with your benefits plan while you're still remaining an employee. And so they have a duty to accommodate while you're off on medical leave. And that's the other side of the coin too, is the employer has a duty to accommodate you being off on a medical leave and to accommodate your medical issues to the point of undue hardship. Section 13 of the Human Rights Code, if you want to look it up, it's a good one. And it says employers cannot discriminate against you based on mental or physical disability, amongst other things. And so I should also mention that there are complaint processes available if you've been bullied and harassed in the workplace, and WorkSafe has a complaint process for that. And so explore the opportunities. Don't let it linger. Please, if we could encourage you to do something, take action to at least look into it, see what your doctor has to say, and chart notes need to be created to at least preserve your legal rights down the road.
Beautiful. Thank you so much, Richard. This next question is for you, Leah, which is, my employer was supposed to accommodate my disability, but they haven't. I want to quit, but I also want severance. Can I have both?
Yeah, so now we're getting into the kind of the meatier questions about some of these circumstances when it's not truly your decision to leave. Unfortunately, this does happen. Employers they make, poor decisions, and they have a duty to accommodate you up to the point of undue hardship. It's a very high threshold that they must meet in order to show that they're not able to bring you back to work or return you to your position or help you with the graduated return to work plan. So you're requesting accommodation, you're ready to go back, and they're not accommodating you, then they're not acting according to their obligations. And so as long as your accommodation is a two-way street, if you're providing them the medical notes and the information that they need in order to ensure that they can return you and that you're cleared for work, that's an important consideration that you want to keep in mind, that you're cleared or you have some sort of gradual return to work plan that you're providing them. But if you've done that and they're not returning you to work, then again, that's when you want to make those notes to them, right? That you have provided your note that you are able to return on a gradual basis or a modified basis, and that you've yet to hear from them and they're not returning you. So during that period of time that they're not returning you, you're accruing a claim for back wages. So up to the date of when they could have returned you, until either they eventually do return you, or if you decide to proceed with a severance claim, then you're also entitled to the wages that you would have received if you were able to work during that time. So it's important to just keep a record of when that date that you were able to return occurs. And if you decide to quit at a later point and you want to pursue your severance, you just need to make sure that you gave them an opportunity to return you, and either they said, no, we can't, and they weren't meeting their obligations, or they discriminated against you. Hopefully that doesn't happen, but if it does, and it sometimes does, then you can proceed with a severance claim. And not only a severance claim, but you can claim your back wages. And depending on the circumstances, if they're really bad, if your employer's acted really poorly in that situation, then you could claim bad faith, or if you've been accommodated due to a disability, and the situation, say, makes your disability worse, or you're under more stress and you have a medical note, then there could be other types of claims you can make. It's just kind of like a bad faith, or what's called an aggravated damages claim, if you've got continued medical concerns as a result of them not even returning you to work. So you want to pay attention in those circumstances. If they are acting unfairly in that situation, then you do have lots of options and a number of claims you can make and a number of things you're entitled to. The first being the ability to return to work. The second, if you're not, then back wages up to the date that you could be returned, and you can still absolutely proceed with the severance claim, and a couple of other claims that I touched on if they aren't returning you and they don't have a reason to. So important to keep in mind.
Beautiful. Thank you so much, Aaliyah. This next question is for you, Richard. I was laid off with severance. I don't want that on my record. Can I negotiate resignation instead as part of my severance package?
Great question. Aaliyah said, and she said we do this all the time in terms of negotiating exits and packages. So yes, That is possible. Now, a negotiation is always a two-way street, right? So it depends on whether or not the employer is willing to do it. And if they are going to do it, are they going to pin a certain amount of money to it? Like, we'll give you less severance, but we'll agree on the resignation side of things. So it all depends, but certainly we do this. And the record of employment has various boxes. Box 16 will have codes. And so when you code something officially on a record of employment with a resignation, remember, there's an EI implication. There's a consequence. So the official document may say resignation, meaning you can't get EI. So think about it. But also, think about whether it really will make a difference, whether you're leaving under your own steam, and whether an employer will ever see your record of employment down the road. They may never see the ROE if you're going to apply for other work. So it may not make as much of a difference as you think it will, but maybe it will to you. And maybe it's a matter of being able to leave and feel dignified. So consider it. We do that all the time, though, where we do integrate that in.
Beautiful. Thank you so much, Richard. Aaliyah, this next question is for you. I'm thinking about quitting my job. What's the first thing I should do?
It's a good question. It's a very big question, but hopefully I can narrow it down. I think the first part is you want to determine the reasons why. So take a good look internally and gather up all of the things that are leading you to want to quit. Is it things that have happened at work? Are they, if it's truly voluntary, then, that's fine. Maybe that's the only question you need to ask and confirm, and then you can move on. And go ahead with your resignation. You want to look in your employment contract in that situation, see if you have to give a certain amount of notice to your employer. Maybe it's usually 2 weeks, but in some cases, if you've got an unusual position, it could be a little bit longer than that. So just always double check. And then you want to make sure that you give your resignation in writing to your employer so that, if you tell them in the hallway on a Monday and then you don't want to have to stay any longer than you need to just because they go, oh, well, we didn't get anything in writing. So I forgot, was it Monday or was it the Thursday? I don't really remember when I saw you in the hallway or things like this. So make sure you write it down and you send it to them, and you have the ability to show that that's when the date started, so that if you have any resignation notice period, then, it runs the clock at the time that you want it to. But if it's not, and you're looking into the reasons why you want to leave, then you might want to review with counsel. If the reasons for your quitting are somewhat unusual. If it's due to issues with your supervisor, then you may have the ability to make a complaint for an investigation through WorkSafe BC if they aren't following certain requirements to keep a healthy and safe workplace. If there's bullying and harassment issues going on, and you've this is why you might want to seek counsel, is because you have certain options for managing that, and seeing if that can be a resolution first, or you can still leave, but then know that you can hold somebody accountable for maybe some of the failures that caused you to leave, such as making a complaint to an investigator with WorkSafe, and that could start an investigation into your employer to make sure that they're up to date with their policies that they need to have. So even if you quit and it's due to some of those reasons, then, you can change things for the future. Or if it's some of the other reasons that we discussed today, like a failure to accommodate, or because you have had issues with your pay or your duties changing, or again, a toxic workplace, then you may want to seek some advice about whether you can still make a claim for severance or the other types of claims that you can make. So even if you quit and you're not interested in severance, and it's due to some of those reasons, maybe you want to get some advice about the things you can do to hopefully change the workplace for the future. Or you may want to seek advice and see if, even though you're quitting, maybe there's some other options for things that you can do in order to get better protected with respect to a potential EI claim or financial security for the future through getting a severance amount. I think the short answer is if it's an unusual reason for quitting, then know that you can seek advice from someone who can help you organize what's going on and give you a better idea of your options.
Super. Thank you so much, Aaliyah. So we've got 2 more questions, and then we're going to turn to the live questions. Richard, this next one is for you. What's the best way to talk to my employer about quitting my job? Do I need to do it in writing?
The answer to the first answer is nicely, if you can, remember that the other side of this situation is a human being. And in all likelihood, you're speaking either with the owner of the business or a manager at the business, someone who's in a position of control there. They are going to naturally take what you say, and it's just human nature, with a bit of a personal bend. And so if you go in and you're going to be asking for some sort of shorter period or something that you need, remember you get more flies with honey than vinegar, as my mother used to say, right? So I would bear that in mind, that a respectful dialogue with somebody who's a human being on the other side and just explaining what you're going through, that paves the way to a fantastic conversation. And if you're needing something from that conversation, and they might need something as well, like transition of a project or a bit of effort to see something hit a milestone before you leave, there's a give and take that can be wonderful in there. So I would have a conversation face to face or over Zoom or what have you, however you function in your work world. And then after that, I would follow up in writing. So as Aaliyah mentioned, we always want to abide by the law, and terminations need to be in writing. Resignation should be in writing and be clear and unequivocal. There should be no doubt left as to what the terms are once everything is said and done. So an email can be great. It doesn't have to be a written letter signed, although that's a nice touch sometimes. But in 2023, you don't always have to have a handwritten signed letter, right? But follow up in writing. But just remember that you're dealing with someone on the other side who doesn't want to hear every grievance you have about the workplace over the last 5 years. So think about what your interests are. Think about what their interests are. Try to hit some mutual ground, and then kind of clarify in writing what that looks like.
Beautiful. Thank you, Richard. Aaliyah, this last question is for you, and I'm going to unshare my screen as we're talking, so you'll see a change. I'm struggling to make a decision about whether to leave my job. Who can help me with this?
Thanks, Paul. It's a big question. So I think there's two ways to look at this. One is, if you're thinking of moving jobs, then that's a deeply personal decision. And, who you make that decision with, whether it be your mentors or your loved ones or whoever else you check in with to make those types of decisions, or maybe it's a decision you make yourself, then, you don't need to really seek outside help. But if it's one of the situations that we talked about today, like you feel pushed out, it's a toxic workplace, you're not being accommodated, your duties are changed, and you feel like you need to leave because of one of those things or some other things are going on, and that's influencing your decision to leave, then you may want to, WorkSafe BC is a fantastic resource. They usually include information on their website about what employers' duties and obligations are for a healthy and safe workplace, because you have a right to a healthy and safe workplace. You can ask your employer for their bullying and harassment policy, or if they have a respectful workplace policy, to see if there's a procedure for addressing some of your concerns, if that's the specific reason that you feel like you need to leave your job or forms part of your reason for leaving or wanting to make a decision about leaving. Kind of gathering information is always a good first step to determine, well, what's the standard that I should be comparing my situation against? And is what I'm experiencing normal or not? If you know that it's completely out of line and it's just beyond what can be expected in a normal workplace, and you need some more help about what your options can be, and you're, looking to take a more proactive approach, then you can certainly seek out legal counsel. It's just not always, I don't always just knee-jerk respond that you need to seek legal counsel. Sometimes it can be, okay, you've determined that you want to leave, but if you truly feel pushed out and it's not your decision and you like your job otherwise, but maybe a new manager came in and he's mistreating you, or all of a sudden the job is reorganized and you now have to commute 25 kilometers, to Chilliwack or something, or, things are being changed about your bonus structure or your duties, and you're now working in a back office, or you got injured and you're not being returned to a job that you can reasonably do, and it's just creating more issues with your injury. and you're trying to determine whether you should leave in those situations, then I think it does help to get some more specific legal advice about what rules your employer is supposed to follow, and what they were supposed to do for you in that situation, so that one, you can either respond to them and ask them to do those things. Hopefully then and there it gets solved. Or if it doesn't, then you're well set up for being in a position where you can claim severance, you can get EI if you have to leave. You get a little bit of a financial buffer so that you can make the next right decision that's best for you and find a better job that suits your needs, that is going to treat you a little bit better.
Super, thank you. So we've got a number of questions that have come in through the Q&A. Richard, I'm going to put this one to you. If you're past your probation period and you're let go without notice with 1 week of paid out, what happens if the employer, so there's that piece, you're let go without notice after your probation period. What happens if the employer gives you a letter and says, if you sign the letter and promise not to sue us, you'll get X dollars? Are you entitled to any amounts if you don't sign due to a hostile relationship?
Yes, potentially. So the issue there, it's called a release document. Okay. And so what they're saying is, assuming you're being terminated without cause after 1 week, or after the probationary period, sorry, you're entitled to 1 week under the Employment Standards Act. You may be entitled to more if there's no written agreement that says you only get employment standards. A lot of employers will say, we're going to give you an additional amount to make sure that there's finality to this. You get something additional, but in exchange, we want the finality of knowing you've signed away your legal rights and we're not going to face a lawsuit. And so what you need to do before you sign that document is look before you leave, because you may be waiving your right to go after a bullying and harassment complaint, a human rights case. Maybe you have outstanding wages you're entitled to under employment standards, or maybe you're entitled to more severance because there was never a proper contract in place. So you really need to think about what the dollar value is they're putting on the table in exchange for that document, because they are generally binding once you sign them, as long as you've been able to turn your mind to the situation and sign voluntarily without duress. So that's where even a little bit of time doing some research and potentially getting legal advice, for example, that can be really, really beneficial. What a release like that, I could drone on about this for hours, but what a release like that is going to need to have in there, if you're waiving employment standards or human rights or WorkSafe entitlements, is it needs to say in there, you are giving up the right to WorkSafe complaints, etc. So you just need to also look at the language and get some guidance on whether or not it's an enforceable release.
Beautiful.
But it's a very common process.
Oh, I was just going to add, Richard, in your experience, I mean, I know for me, I used to act for, many different employers, and generally speaking, if they're offering you some sort of amount for a release, it's because you're entitled to more. So that's just my perspective on that. It's worthwhile getting that reviewed by somebody else that acts for you, that's interested in your position and not the employer's position, because unfortunately, my experience is that employers generally don't offer anything unless they have to. And if they're offering you that amount in exchange for a release, it's usually because you're entitled to a lot more, or they could be exposed to a lot more, and they're hoping to avoid that by getting you to sign. But that's just my 2 cents. Of course, it depends on the circumstances. So it's a good thing to review.
Yeah, and this leads us nicely, Leah, you might take this question to one of the questions that came in. Is it legal for an employer to make an agreement while terminating, enforcing to sign the document stating not to seek a lawyer?
No, yeah, I think so. What I understand that question to be is it legal for my employer to ask me to sign a document that says I will not seek legal counsel? That would generally not be recommended, even if you were acting for an employer. The reason why is because if they are asking you to enter into a document like a release, and I think I see something in the chat about this, if it's under duress, exactly, then it's not going to be enforceable. And so generally speaking, you might see in employment agreements or in the release itself that both parties have been advised that they have a right to seek independent legal advice. And they're either they acknowledge that they have that right and that it's been brought to their attention and that they're waiving that right, or that they've otherwise taken the steps they need to inform themselves. and then they're still deciding to sign the agreement, because in those circumstances, you get a very binding, enforceable agreement that is very hard to challenge. If it's under duress and you're being forced to sign it, or if you're signing away your right to receive independent legal advice, that starts to look a little bit fishy and suspect, and like you're signing under duress. And that starts to look like something that isn't a binding legal document. So if that's what's going on, I think that you're kind of at that stage where you probably want to seek legal advice, because it sounds a little bit unusual, a little bit fishy. But of course, it's up to you. Those are just my 2 cents about that.
Beautiful. Thank you, Leah. And we're almost at the top of the hour. And so I've got one last question. It alludes to something, Richard, that you spoke of earlier. And then we're going to have to wrap up. And just wanted to thank everybody who wrote in with their question. There's some really excellent questions in the Q&A. Richard, the question here is, will my future employer find out if I quit or get fired?
There will usually in the interview process be a question put to you as to why you've left a certain position. And if you lie, for lack of a better term, to a potential employer, that can be used against you in the future if they find out that there was dishonesty in the hiring process. And so honesty is the best policy. Now, that doesn't mean that you have to unveil every potential thing about the situation, but it's really important that you not say you resigned if in fact you were dismissed. And employers generally understand that, especially in this day and age, there are a lot of economic and other factors that result in people being dismissed due to no fault of their own. There's not stigma to that generally. And so if you've been let go, it's okay. I would urge people to see that that's something that future employers don't hold against you, unless you were dismissed for fraud or for theft or for something that's incredibly serious due to misconduct, right? So they won't find out otherwise, except through you, or if they do a reference check. And so you want to make sure that you're being honest with your future employer, but that doesn't mean that you don't have an explanation. And that is your right.
Beautiful. I'm going to ask our speakers, Richard, I'll start with you. What maybe some takeaways or what maybe something that we didn't cover in today's session, or something that we did cover, that you would just like to highlight for anybody who's in a position where they're thinking about leaving their job?
Reputation is key. And in this day and age, in this landscape of the economy, with gig economy and independent contractor arrangements and all sorts of different iterations of work, you will carry a reputation and a brand with you no matter what job you're doing or where you are in an organization. And so just think about that. But the coming and going to and from jobs is a staple. That is becoming more commonplace. People are generally not staying at the same place for 30 years anymore. And so change can be hard. I think if we can appreciate that change is hard, and those conversations with employers when you're leaving are hard, and interviewing is hard. Honesty is the best policy, but understanding that that's all part and parcel of our workplace these days, and that not everything has to be career long, except brand and reputation, will help us to kind of think through some of these things and just make good decisions as we come and go from jobs.
Beautiful. Thank you so much, Richard. Aaliyah, we'd love to hear from you, your thoughts in terms of a takeaway or something that you would invite someone who's thinking about leaving their job to think about.
Yeah, well, I'd say that information is power. The more that you know, the better that you can make decisions for yourself. Unfortunately, I feel like in this day and age, either there's so much information that it's just difficult to sort through it, or there's not good quality information, or there's a lack of information. So sometimes it can help to get a good source of that, like the People's Law School, like sources online, if you have if you're able to do that research, or to use the resources available to you to make sure that you are empowered to make the best decision for yourself. So regardless of what you end up doing, that you know that it wasn't because you missed something, or you weren't aware of what your options were, or you felt forced into a corner, because you should never feel that way. And there are always things that you can do. If not, know that you did the best that you could and have that peace of mind. So if I had to kind of leave everybody with one thing, is that you're all taking that step, I think, by attending this presentation. So you're interested in informing yourselves, and it truly is the best way to protect yourself and to be your own advocate.
Beautiful. I love that you said that, Aaliyah, because it really is summing up really nicely what we're doing here today, right? The information that you and Richard are sharing, our guests being here and taking that first step toward informing themselves. There are resources that are available, including on the People's Law School website, and we'll provide links in the notes that will accompany the recording of this webinar. So there's some information there as well. So such a great way to finish off today's session. So thank you again, Aaliyah. Thank you again, Richard. It was such a pleasure having you here. Thank you to everybody who joined us here today. We will now finish up with today's broadcast, and thank you again, and look forward to seeing you in September.